Good afternoon, everyone, and welcome to the webinar, Prosecuting Sexual Abuse and Confinement, a Case Study. My name is Charlene Whitman, and I'm an Associate Attorney Advisor at AEquitas, the Prosecutor's Resource on Violence Against Women. I'll be moderating and participating in today's webinar. AEquitas has previously presented 4 PREA and prosecution webinars, which have been archived and can be accessed at the following 2 links: on the AEquitas Library webpage, training webpage, and also on the PREA Resource Archive web pages. For the best use of ILING, please use the call into our conference line. The number is 530-881-1212, passcode 202-731-738. And that number is in the top left-hand portion of your ILING session screen. And please do call in from a landline. If you're using a mobile phone, please do not use the speaker option. If you have technical issues, you can use the ILING hand raise indicator, which is located on the toolbar in the top left-hand portion of your screen, or you can contact ILING directly at 1-800-799-4510. Throughout the webinar, questions may be posed to all participants, and you can respond to those questions by using the ILING feedback indicator located on the left-hand portion of your screen below the attendee list. You can also post comments or questions via private chat to me, Charlie Whitman, and I will share your questions anonymously with the presenters so they can be addressed throughout the webinar. We really do encourage you to submit questions and comments throughout the presentation as you have them. Today's webinar is hosted by AEquitas, the Prosecutor's Resource on Violence Against Women, and the National PREA Resource Center through funding from the U.S. Department of Justice, Office of Justice Programs, Bureau of Justice Assistance. Written materials, including a copy of the PowerPoint presentation, presenters' biographies, and a link to a short survey will be emailed to you following today's presentation. Just a note, this presentation is also being recorded for later viewing. The National PREA Resource Center was established through a cooperative agreement between the Bureau of Justice Assistance and the National Council on Crime and Delinquency. The mission of the PRC is to assist adult prisons and jails, juvenile facilities, lockups, community corrections, and tribal facilities in their efforts to eliminate sexual abuse by increasing their capacity for prevention, detection, monitoring, responses to incidents, and services to victims and their families. AEquitas' mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. AEquitas provides prosecutors with the support, training, mentorship, and resources necessary to objectively evaluate and constantly re-examine and refine their approach to justice. AEquitas staff conduct legal research, provide 24/7 case consultation, host specialized or state-specific training events and webinars, provide individual experts to jurisdictions and organizations, and publish articles, monographs, and other resources on topics relevant to the prosecution of violence against women. This slide contains a brief synopsis of the passage of PREA and its standards. The PREA legislation was passed into law in 2003. In June of 2009, the report and draft standards were published by the National Prison Rape Elimination Commission, and in May 2012, the final Department of Justice standards were released. On June 20, 2012, the final standards were published in the Federal Register, and those standards became applicable to the Bureau of Prisons on August 20, 2012. We're now in the time period of the first audit cycles from 2013 to 2014 of corrections facilities. Today's presenters will be AEquitas Attorney Advisor Viktoria Kristiansson and Mona Shea, Assistant District Attorney in Travis County, Texas. Prior to joining AEquitas, Vicki served as a Deputy Attorney General and Special Assistant to the Attorney General of New Jersey. She also served as a Senior Attorney for the National Center for the Prosecution of Violence Against Women and as an Assistant District Attorney in Philadelphia, Pennsylvania. Mona Shea currently serves as an Assistant District Attorney with the Travis County District Attorney's Office in Austin, Texas. She's responsible for prosecuting all levels of felony criminal cases and helps to coordinate investigations and consults with law enforcement. Prior to joining the District Attorney's Office, she was an Assistant County Attorney with the Travis County Attorney's Office, where she prosecuted misdemeanor family violence cases. Now I'd like to turn the substantive portion of our webinar over to Vicki and Mona.
Good afternoon, everyone, and thank you so much for joining us. As you can see on this slide, we wanted to start out before we got into the case by giving you a sense of just how big the issue is, and the issue being sexual abuse and confinement. As you heard from Charlie a little earlier, The original act, the Prison Rape Elimination Act, was passed in 2003, and over the last 10 years, there have been a number of persons and organizations working to develop the standards that ended up being issued last summer, 2012. And back in 2003, when the act was issued, the act contained some findings, and the findings included the fact that there were more than 2 million persons incarcerated in the United States at that time. There were more than 1 million of them in federal and state prisons, and about 630,000 of them in local and county jails. And the percentage of inmates at that time who had been estimated to be sexually abused while in prison was around 13%. The most recent Bureau of Justice Statistics studies indicate that about 9.6% of former state prisoners reported one or more incidents of victimization during their most recent period of incarceration. More than 75% of all reported staff sexual misconduct in state prisons involved a male inmate and a female staff member. And that's interesting because that's certainly not consistent with the numbers that we hear in terms of sexual assault that occurs outside of a confinement facility. For former state prisoners, the rate on inmate sexual abuse was 3 times higher for females than males. And when we're talking about former prison and jail inmates, 13.7% of male and 17.2% of female inmates reported a violent sexual inmate-on-inmate incident. So what are we seeing in terms of timing, and what are we seeing in terms of reporting? Well, 1.5 male inmates reported sexual abuse by another inmate within the first 24 hours of entering a facility, and 1 in 3 reported sexual abuse by a staff member within the first 24 hours of confinement. And what we know from studies is that inmates are at increased risk of sexual victimization. We find those who typically suffering from some kind of mental illness. They are young first-time offenders. Especially we see this when we have juvenile offenders who are housed in adult facilities. And inmates who are gay or are perceived to be gay are at increased risk of sexual victimization. So while we have the passage of the Act and the standards, we've been working on this for the last 10 years, so we've already significantly increased the number of corrections and other allied criminal justice professionals who have been trained on sexual abuse and confinement. While those numbers have increased, we're still not seeing a lot of cases that are getting reported, and thus they're not getting criminally investigated and prosecuted. And that's one of the reasons that we wanted to highlight this case today. So at the conclusion of this webinar, you should be better able to identify the dynamics of sexual abuse and confinement and the impact of those dynamics on reporting, investigation, and prosecution of cases, collaborate and communicate with all of the allied criminal justice professionals in your jurisdiction, the advocates, the sexual assault nurse examiners, correction staff, law enforcement, prosecutors, to ensure that the victim is supported throughout the initial contact, the investigation, the trial, and the sentencing processes, and of course afterwards. Thoroughly investigate cases by uncovering and corroborating as much evidence as you possibly can, and then prosecute those cases by utilizing trial strategies that focus on the offender's behavior, the offender's predatory tactics, and of course at the same time provide an understanding of the confinement setting in which the sexual abuse occurred in the first place. As Charlie mentioned, we encourage you throughout the webinar to ask us questions and to challenge us. We imagine that some of you have seen cases that present some similar facts to the facts that you're going to hear today, but also we expect that you're going to have seen cases that have significantly different facts. And so if you have some kind of hypothetical question or question about a case that involves different facts, please let us know. For this webinar, we changed the dates, the names, and other specific identifying facts. But we want to let you know that the county jail in which this incident occurred houses about 2,500 inmates in 7 different buildings. It houses pretrial inmates. It houses those serving time for misdemeanor convictions. And in this jail, inmates are housed in particular units according to certain work assignments and certain behavior requirements. In this jail at the time that the offense was committed, the only offenses that were taken into consideration for housing, etc., were homicide, were murder. And certainly we'll talk about this during the webinar, that under PREA standards, that certainly isn't the case anymore in terms of the assessment and intake when an inmate enters a jail or prison. So I'm going to turn the webinar at this point over to Prosecutor Mona Shea, who is going to start to talk about the case that she prosecuted. Mona?
Hi, good afternoon. I just want to mention before I start talking about the specific facts of this case that in the office that I work in, all sexual assault and homicide cases are prosecuted laterally and given to the prosecutor assigned from the very beginning. So we have it from pre-indictment all the way through to the conclusion of the case. And that was the case in this case. So the facts of this case are, on July 15th of 2010, in the early morning hours, the victim, and this is not his name, the victim was in the inmate jail bathroom washing his face, brushing his teeth, and getting ready to go to his work assignment. The defendant approached the victim from behind, grabbed a hold of his neck with one hand, and he pushed him into a nearby shower. As he was pushing him into that shower, the victim scraped his shoulder on the shower wall and caused an abrasion. The defendant then closed the curtain to the shower. He stated, "I've been to prison before and I'm probably going back, so don't say anything. You just take it." He stood behind the victim, pulled his pants down. As he was pulling his pants down, he scraped the victim's penis with his thumbnail, causing an abrasion there as well. He then penetrated the victim's anus with his penis several times. The victim reports feeling severe pain, but did not say anything due to the fear that something worse would happen to him. The defendant then threatened him by saying, "You don't say anything, or I'll find you when you get out." He then left the room and went to the laundry room to do his job. After the defendant left, the victim pulled up his pants and went to report to work as well, which was also in the laundry room. The victim had no further contact with the defendant that day. They saw each other while working, but they didn't talk or have any other interactions. Later that day, after they returned to the unit, the defendant approached the victim and told him that he needed to relinquish his job in the laundry room and transfer to another unit. The significance of that is that inmates who are assigned to work in the laundry room are considered trustees, and they receive 3 days of credit for every day actually served. So when this victim requested to move off of this unit, he knew he was giving up good conduct time. The victim approached a corrections officer, signed a transfer form, and was moved off that unit later that night. He was transferred to another housing unit in the jail. And for the next 2 nights, staff reports and the victim reports, he was unable to sleep and vomited throughout the night. On July 16th of 2010, the victim reported the sexual assault to a staff member of the jail. He did this by passing a note to the staff member where he laid out what had happened. That staff member immediately told his superiors and followed the protocol that they're taught to follow, and eventually local law enforcement was called out to the jail to investigate the offense.
So our question at this point, and we're really interested in hearing from you, our participants, is was that officer, was the corrections officer's decision to call law enforcement at that point appropriate? And you can just answer that with a yes or a no. And when we start to hear from you, we'll certainly share.
And as the answers are coming in, it seems like the majority of folks are saying yes, that was an appropriate decision to make. And as the PREA standards say that inmate corrections officers are required to report any abuse or any suspected abuse to someone within the facility, and they must report it immediately according to agency policy. Now, they are allowed designated to report that in such a way that doesn't reveal any information related to the report, but as specified in the agency policy, such that they can make treatment, provide investigation, or other security and management decisions.
Yeah, so this has to be reported to the facility, but the steps afterward depend on the anonymous reporting options in the jurisdiction, and of course, under PREA, there has to be an anonymous reporting option. So the call to law enforcement under PREA standards is still an appropriate thing, but under PREA standards, there should not be a mandatory cooperation involved for the victim. The victim, there can be a transport, there can be a conversation, but under the PREA standards, the victim should have the ability to choose whether to participate in the criminal justice process. And our second question for everyone is whether the jurisdiction in which you work has anonymous reporting for cases of sexual abuse and confinement, if you know.
And those numbers are coming in as well pretty quickly, Vicki. And again, the majority is saying yes. There are a few notes, but it's encouraging to hear that the majority is yes.
Right, and that's because the PREA standards require there to be an anonymous reporting option. So that's good. Across the country, we're still seeing some jurisdictions who are trying to become PREA compliant and trying to figure out some ways for there to be anonymous reporting. I mean, obviously, logistically, there are some challenges with this. So if anybody is in a jurisdiction working on this, you can certainly reach out to us or the PREA Resource Center, and we'd be happy to talk to you about what is going on across the country and some successes that other jurisdictions have met.
And the PREA guidance around first responder duties is that you have to separate the alleged victim and abuser. Preserve any crime scene until appropriate steps can be taken to collect any and all evidence. And if the abuse has occurred within a time period where collection of physical evidence is possible, you're required to request the alleged victim and the alleged abuser not take any actions that can destroy physical evidence, including appropriate washing, brushing teeth, changing clothes, urinating, defecating, smoking, drinking, or eating. Try and save as much as you can.
Mona, in your case, was there, I realize, we've discussed already that your case occurred prior to issuance of PREA standards, but was there an effort by corrections to secure that crime scene?
There was not. And I'm not sure if it's because, based on the facts of this case, they didn't think that they would get any evidence from that crime scene. There wasn't any, for example, blood evidence to collect. There wasn't any indication that they would find ejaculation or anything in that area. So I'm not sure if it's because they didn't think to do it or they didn't think they would get anything, but it was not done.
Mm-hmm.
And so after the police were notified, 2 officers respond to the jail to kind of talk to the victim and start the investigation. The officers met with the victim in a private conference room and conducted an informal interview. And the victim reported that he had been assigned to the top bunk across from the defendant's bunk, that he did not have his clothes from the incident because the inmates, when they come from their work assignments, they're required to change before they enter back onto the unit. And there's no way of telling, since they're jail uniforms, there's no way of telling which one was actually his. He reported that he had showered at least twice since the incident. After talking with the victim, the officers went through to the jail staff and obtained the written job transfer request, as well as the note that the victim had given to the staff member initially. They met with him in a private conference room. Like I mentioned, it was an informal interview, and they learned that all of those facts that he reported to them with regard to the bunk beds of the victim and the defendant, that was corroborated through jail records, and they also corroborated the scheduling and the washing and taking of the clothes coming to and from the unit. So they start the initial investigation. They're seizing the evidence that they have available to them, and then the policy is that they then contact a detective, a sheriff's office detective, and that's a detective that's assigned to Major Crimes Unit, and he reports to he takes over the investigation. What's interesting and important to note is that these two initial responding officers did an excellent job of documenting their interaction with the victim, and they documented things like he was nervous, he was scared, he was trying not to cry, he was holding back his emotions, and they also documented that they could tell that he was in physical pain, that he was having difficulty sitting down, that he kept moving from side to side, and they talked to him about prior contact with the defendant, and he recalls seeing him but never had any actual contact with him other than this particular offense. And I think that's important. We do training with our law enforcement officers, and I think it's important that we're reminding them to write down things that they're observing, because a lot of times they're focusing on what the victim is saying, and as we all know, that's hearsay, and so for them to document the things that they were seeing that would corroborate that this offense had occurred was really important here. Throughout the interview, the victim appeared nervous and scared. At one point, one of the officers kind of told him, calm down, we're going to get through this, hold back your emotions, because he was getting really upset. And they documented the extent of physical pain that he had been in. It's important to talk to the victim about prior contact, because it's important to know whether, as a part of your investigation, you're also going to be looking at and taking witness statements regarding witness intimidation. And that's something we can discuss more. In this case, it didn't apply, but it's important to remember, that officers remember to do that and ask those questions. So they immediately started corroborating what the victim had said with whatever physical evidence they could think to get. And that's also important because, it's a he said offense, and most times it is. And so even little things that you don't think are important, like the transfer slip or corroborating where the victim and defendant were sleeping, those things can help us, to support the victim's testimony in front of a jury. So here they found documentation from the jail staff that the victim had been throwing up since the incident occurred. They have the housing inmate roster confirming the sleeping arrangements. The initial officers took pictures of the victim's injuries and took pictures of the shower area where this happened. They did informal kind of asking around of the immediate staff that were there when it happened, but did not take any formal interviews of other inmates or other staff members. Officers interviewed staff and were told that the victim had been unable to sleep and had been throwing up since the time of the incident. They also interviewed the unit officers and the laundry staff, but no one reported anything unusual between the victim and the defendant. Officers obtained a copy of the inmate housing roster for the morning of the incident of the sexual assault. A detective came to the jail and interviewed the victim, took more additional pictures of the victim in the shower, and attempted to interview the defendant. The detective also is the one that needs to authorize the sexual assault nurse exam. That was done, and the victim was transported to the hospital to have that exam done. Additionally, the responding officers also dispatched a victim witness counselor to meet with the victim. This victim witness counselor works for the sheriff's department, so she works for a law enforcement agency, not the jail. She did not take no formal interviews were done with any of the other inmates, like I said. It's made clear to the victim that the counselor does work for law enforcement, and the role of that counselor is more as a liaison and a support person, and that counselor gives referrals to the victim for other advocates and other victim support. There's confidential advocates are important, where the victim knows what is being said isn't going to be repeated, but that he was under, he was very clear that was not this victim witness counselor's role. The victim witness counselor in this case is a certified counselor, and she's in plain clothes. She comes and talks to the victim, usually at the site of the offense. The counselor meets with them prior to a formal interview done by the detective to answer any questions that the victim may have and to provide support and help the victim to handle anxiety and that kind of thing. This victim witness counselor also did an excellent job documenting the victim's demeanor. She also files a supplement report for the offense report, and when she showed up, she asked him how he was doing, and he shrugged his shoulders and began to tear up. He indicated to her that he felt ashamed. She told him the rape was not his fault. He had no control over the abuse, and he had nothing to be ashamed of. She then commended him for taking the first steps towards recovery. And like I had mentioned, in Texas, these victim witness counselors are a part of the immediate response team that come to any violent crime, and they're on call just like a regular officer, and they're called into the scene of the crime. The two responding officers who first went to the jail were the ones who paged this victim witness counselor to the jail. It's important to note she is not a certified rape advocate. She's a victim liaison, and therefore, like I said, communications between her and the victim are not confidential. These two met in a private interview room. She introduced herself and explained her role. She went on to shake his hand, and she observed and noted and documented that his hand was shaking, and he was anxious and embarrassed. She asked him how he was doing, and he shrugged his shoulders, and his eyes began to tear up. She asked him if he was feeling ashamed, and he nodded his head yes. She explained it was not his fault, and he had no control over the abuse, and he had nothing to be ashamed of. He questioned whether he should have been able to prevent the abuse, and she said this is a normal reaction, but he should not place the responsibility on himself. He should place it where it belongs, on the defendant. She stressed that the victim did what he had to do to survive, and she commended him for taking the first steps towards recovery, which is speaking up and accessing services and reporting to law enforcement. The victim shared some concerns with the counselor. He said that he was concerned about disclosing the incident to his family, and he initially was unsure whether he wanted to press charges. The counselor responded by stressing to him that corrections and law enforcement officers would support any decision he made and that he did not have to make the decision at that time. He reports fear of the defendant due to the defendant's threat of harm to him, and if he told anybody about the sexual assault, and he was concerned. He also expressed concerns that others would be harmed if he did not officially report the abuse and help with prosecution. He said he didn't know whether he had concerns about disclosing the incident to his family, although he thought they would be supportive. He also said he didn't know whether he wanted to press charges. She reiterated that it was completely up to him and that he did not need to decide right now, that they would support whatever decision he made. He discussed, again, his fear of the defendant, that he would harm him again or harm somebody else. The victim reports that... Oh, go ahead.
Mona, I just wanted to jump in. I think we had some unfortunate technical issues and wanted to jump in with some PREA standards on confidentiality to support what you're talking about and the difficulties that this victim was experiencing, and how the PREA standards do require that you provide inmate victims with multiple means of reporting and provide them with access to confidential advocates, as you were talking about, and that you provide them with addresses, phone numbers, toll-free hotlines, enable reasonable communication, and inform inmates about monitoring and mandatory reporting where possible, where the agency policies and the state law permit. So I apologize for interrupting you, but I did want to get that information in because we were talking about that a little bit before and the difficulties as well. And noting that around 34 of the states, including the District of Columbia, do have that confidentiality for domestic violence and or sexual assault advocate privilege, including Texas for certified certified sexual assault counselors.
Right, and in Texas, both the victim witness counselor responding to the scene and the victim witness counselor that responds to the SANE exam scene, they both provide information with regard to how victims can access those services.
So both the confidential and the non-confidential.
Exactly.
Okay.
And so this victim witness counselor also acted as an advocate for this victim. After the interview, she went and followed up with the jail staff. She spoke to the sergeant in charge, and she noted that the victim did want to follow up with advocacy and counseling service. She explained what had happened with the job transfer and explained that the victim wanted to return to his job and continue on the trustee unit once he learned that the defendant had been removed from that unit. And so she helped the victim access the staff to help him do that. She also talked with the sergeant in charge at the jail and indicated that he had been forced to relinquish this job under duress by the defendant and that he would like to return to his job.
So even before, in terms of talking about this, the way that the case progressed, even before the victim sat down with the counselor, he was transported to the hospital by the first responding officers, where he was examined by a sexual assault nurse examiner. And under the Prison Rape Elimination Act standards, victims of sexual abuse and confinement are entitled to a sexual assault forensic examination immediately upon report. They don't have to pay for the examination at all. And if such a professional is available, the exam has to be performed by a sexual assault nurse examiner or a sexual assault forensic examiner, if one is available. So sometimes what we're seeing in jurisdictions across the country, depending on the nature of the case and the type of injuries, a victim might receive immediate medical care at the facility and then be transferred outside for the sexual assault forensic examination and kit to be done. But depending on the practices in the confinement facility and the hospital, it may be best to immediately transfer the victim to get the kit. And sometimes that's because the sexual assault nurse examiners have concerns about evidence being preserved, about being able to conduct an entire examination. And also when we're talking about victim care and we're talking about minimizing the number of times that the victim has to share the story, has to have an additional examination, we want to try to streamline the services. And there are a number of PREA standards that do cover the provision of these services, and we listed them on the slide. So in this case, the victim was at the hospital for approximately 3 hours, and this was in the middle of the night. I think he arrived about 1:15 in the morning and left about 3 hours later and had the exam at around 2:30 in the morning. And the exam lasted for 90 minutes. These are really important details for us as prosecutors to know, because we want this to be included in the testimony of our sexual assault nurse examiner, and we want the jurors to understand that in some cases this can be a very long and in spite of course, the best efforts of the sexual assault nurse examiner, this can be in some circumstances a very unpleasant experience. And this is important information for our jurors to understand. That certainly no one would undergo one of these exams were it not important and necessary, had the abuse not occurred. In this case, the statements to the sexual assault nurse examiner were consistent with the statements the victim had already provided to officers. And in spite of the fact that this was an exam that occurred 72 hours after the incident of sexual abuse, the sexual assault nurse examiner found bruising and swelling surrounding the abrasion on the shoulder, that there was the small abrasion on the top right side of the victim's penis, and that there were 3 anal tears visible without magnification that were tender. And this is quite remarkable when we consider the studies. Certainly when we consider the studies on female victims, so when we're talking about penetration of penis and vagina, we rarely see any injuries or tears, and we see it more often in males, but Mona's going to talk about this a little later. The sexual assault nurse examiner testified at the trial talked about how remarkable it was that 72 hours after the incident, there were still 3 tears visible without magnification. The discharge is also something that we as prosecutors should note and should talk to the examining nurse about. Here, the discharge included a personal safety plan for the victim, STD prophylaxis, a need for medical follow-up, certainly counseling, and instructions for assisting with reduction of fear, with coping mechanisms, and with additional interventions and services. And after the examination, the victim did return to the jail facility, and Mona will talk a little bit more about what happened then.
He was transported back to the jail facility, and he was moved to a different unit. He was not segregated or isolated in any way. He was just moved away from the defendant. And was at that point that he made contact with the victim witness counselor that I have already talked about, and eventually the detective.
And a note on the PREA standards right there, Mona, that the PREA standards say that if there is that inmates shall not be segregated unless there is no alternative, where you do have to, inmate victims, where you do have to segregate inmate victims, you have to make sure that they still have access to all programs, privileges, education programs, work opportunities, and then as it becomes available, continue to reassess the housing situation to provide for less segregated options.
And so after a detective was assigned to the case, the detective approved the SANE exam, and then the day after the report, he reviewed all of the paperwork, collected all of the evidence that the first two responding officers had taken. He checked on the photographs and determined more needed to be taken, and then he went to the jail. It was at the jail that he took a formal statement from the victim. It was audio recorded in a conference room. The victim indicated to the detective at that time that he did want to participate with the investigation and prosecution of the case. At that time,
actually, Mona, that brings up a really important point, and that is when we should be asking a victim if he or she wants to participate in the criminal justice process, i.e., if he or she wants to, quote unquote, press charges. And really, that should be at the end of an investigation. So we should be responding. We should be responding in a way that's completely consistent with our professional duties and with supporting the victim. And then as the investigation is winding up, there should be a conversation with the victim about proceeding and participating in the criminal justice process. There's a different situation if right off the bat the victim is indicating that he or she does not want to participate. That's a different story. But in the way, when we consider the way the process should be going, we want to wait so that we can appropriately answer all the victim's questions about the investigation and about how the case might play out at trial.
That's right. And after he interviewed the victim, he initiated with his support staff for somebody to begin to compose a photo lineup for the victim to look at, and then he went to see the defendant. He went to the defendant's unit and asked the defendant to follow him down the hallway so that they could talk. During the walk, the defendant's attitude became very aggressive, so the officer immediately Mirandized him. Upon arrival in the conference room, the detective advised the defendant that he was a suspect in a sexual assault and asked what happened during the morning of the incident. The defendant denied raping anybody and said he wanted to know who was accusing him of it and said he would never do anything like that. Vicki, do you want to talk about the PREA's required response to defendants' interviews?
To defendants' interviews? Well, certainly, if we're talking about a staff offender, what we want everybody to keep in mind is certainly garrity. And all facilities have been aware of this case. This is a New Jersey case. Certainly, and you essentially cannot give a staff employee the choice between having some kind of administrative or job-related penalty and talking. You can't say, you have to talk to us as part of your job. We have to interview you. So under this case, you can't compel an employee to talk. As far as PREA requirements, a defendant ends up who's an inmate, has the same exact constitutional rights that he or she would have outside of confinement when it comes to an officer conducting an official interview of the defendant. We still need to be Mirandizing the defendant.
Okay. And so this defendant stated he was being falsely accused. He said that he was being accused because he was always telling other inmates how to do their daily tasks in the unit. He repeatedly said he had been in prison before, and he said he would not do something like that. It was not a very long interview because he determined his position pretty early on, and the detective wasn't able to really get much further with him. After he walked him back to the unit, the defendant became very loud and aggressive. He was yelling at the other inmates that someone had said he had sexually assaulted them, and the corrections officers handcuffed him and moved him to a more secure housing unit. And again, this was before PREA standards came into effect, so those didn't apply to this particular situation. After the interview, the detective, again, tried to put the defendant back onto the same unit that he was on, and they ended up having to move him to a more secure facility. The defendant just kept reiterating. He's saying that he didn't know what he had been accused of. He had issued repeated denials. He didn't understand why the guy would say this because he didn't do anything to him. After the detective showed the defendant a picture of the victim, the defendant said he had bunk next to him and they had worked on opposite ends of the laundry. The defendant also, at that time, the detective requested a saliva sample to use as a DNA known sample, and he consented to that and signed the consent form. After agreeing to give the statement and signing the standard Miranda card, the defendant said he didn't do what he had been accused of. He didn't understand why he was being accused of it, and just again reiterated that he had minor contact with him, seeing him in the bunk. This defendant had extensive criminal history, and most of it being violent. He had 24 convictions, mostly for, again, violent offenses. He had an aggravated assault with causing serious bodily injury conviction, an assault causing bodily injury conviction, an assault to a family member, terroristic threats, burglary of a building, burglary of a vehicle, unauthorized use of a vehicle, criminal mischief, evading arrest 6 different times, resisting arrest, unlawfully carrying a weapon, driving while intoxicated, reckless driving, criminal trespass, and unlawful restraint. This defendant's 25th arrest is what landed him in jail this time. The charge, he was paroled on a felony where he had gone to the penitentiary, and he was paroled to our county. He didn't have any ties to our county. That's just where they happened to parole him. While he was out in our county, he was charged with assault, family violence on a woman he met here. And when he was arrested on that assault, family violence, that triggered a parole violation warrant to be issued. The victim in that assault case declined prosecution, and she would not participate with the county attorney's office in prosecuting that. So that charge did not result in a conviction.
And a note here on assessment, the PREA standards are designed to keep dangerous inmates away from other inmates, so they require that upon intake or transfer, there has to be an assessment within that first 72 hours. And the agency or facility has to use an objective screening instrument, and what they're looking for is risk of victimization. They look at things such as disabilities, age, physical build, prior convictions for sex offenses, perceived sexuality, or prior victimization. They also look for risk of abusiveness. When they look at prior acts of sexual abuse, prior convictions for violent offenses, history of prior institutional violence or sexual abuse, and they're required to constantly reassess inmates. And that information is used to inform housing assignments, beds, work education programs, work education and other program assignments, with the goal of keeping separate, once again, those inmates at high risk of being sexually victimized from those at high risk of being sexually abusive.
And that's very different than what happened in this case. There was a very informal screening process done that clearly did not look at this defendant's criminal history. The classification sergeant says that they look at the behavior of the defendant while in jail primarily as their indicator of where to place them.
And this is really important for us to think about because historically, what happens inside the walls of confinement institutions is something that prosecutors really haven't known that much about. And certainly for these cases, as well as any case that's going to occur in one of these facilities, we need to know. We need to know what's happening and also what's happening with any kind of internal disciplinary proceeding. So in this case, we wanted to know what happened within the jail while the criminal investigation was ongoing. Well, a few days after the victim first reported the rape, the defendant, in fact, did have his internal disciplinary hearing, and he was Mirandized at that hearing. The reported facts were read to him, and that's significant because we know that the victim did not have to participate in the jail disciplinary hearing. And, of course, consistent with what the defendant had done up to that point, he again denied having sexually abused the victim. He was found guilty by the burden, which is a pre-required burden. It can be no higher than preponderance of the evidence. He was found guilty of by preponderance of the evidence of his disciplinary hearing, and he was sentenced to 30 days lockdown with a loss of privileges. And this was what happened in this case in terms of procedures that were set up was that the hearing was audio recorded and sent to the detective. So that's also something that's very, very important to occur. There's certainly also some PREA standards that govern these administrative and disciplinary hearings. Charlie, do you want to talk about those PREA standards?
Yeah, so the PREA standards provide some guidance on how to conduct criminal and administrative agency investigations, and what they say is that they must be prompt, thorough, and objective. You have to utilize specially trained investigators, and there are some outlined standards that talk about what that special training requires, training on sexual assault dynamics and confinement, among many other things. So it's a pretty extensive list of how you train these investigators. As Vicki mentioned, the evidentiary standard for administrative investigations is capped at, it can be no higher than the preponderance of the evidence. And then as the investigation goes on, whether it's a criminal or an administrative investigation, you have to follow up with the inmate victim, providing them with information on case updates. This is also true if an outside agency or an outside law enforcement agency is conducting the investigation. You have to continue to follow up with that inmate victim. Also, even though the standards don't address prosecution directly, they are intricately tied together. And the investigation is a lot of the standards they talk about investigation requirements and guidance and things like that, but it's all evidence collection is for subsequent criminal prosecution. That is provided in the standards. So they are tied together, even though the standards don't directly address prosecution.
And Mona, in this case, I know you had mentioned that there were some other people present at that disciplinary hearing, and then the defendant was, in fact, transferred elsewhere after that hearing. Is that right?
Based upon a finding of guilt at the disciplinary hearing, the jail protocols require that once that happens, a defendant is required to be housed in a single inmate cell. The only single inmate cells that are available at this particular jail are on the maximum security unit. On that unit, the rules are stricter, the privileges are less, and you do not get face-to-face visitation from that unit. So a few days after he was moved onto that unit, he reported to a corrections officer that he had thoughts of killing himself. Based upon that, in the jail protocol, he was then moved to the health services building and placed on full suicide precautions. What I think this was about was the defendant manipulating the jail. He wanted the woman he met in my county that was the victim of the assault family violence, based on his visitor logs, had been to visit him a lot, and he was not going to be allowed to continue face-to-face visitation with her. We think that was part of the motivation behind the suicide outcry.
Right.
And we also think
this is an example of why there has to be that continued open communication between the corrections, law enforcement, and the prosecutor, you, Mona, because this is the kind of fact that if you hadn't known about but had randomly come out at trial, could have been distracting and could have been something that could have been turned into a negative for the case. So it's definitely this is just one more example of the reason it's really important for us to have open communication in these cases.
And I think it's important to also be getting this information whether or not you actually use it in trial, because I think in this case we had so much evidence to use as far as punishment was concerned. I did not use this, but if you have a defendant that does not have the same kind of background as this defendant, this may have felt more important for the jury to know about that.
Mm-hmm. Yeah, and that's all part of the strategy. That's all part of preparing for trial.
And so approximately 10 days after the assault was first reported, the defendant was arrested and charged with sexual assault. The probable cause affidavit was presented to a magistrate, and bond was set at $35,000. That's an extremely low bond for a sexual assault in my jurisdiction, but I think it's because it was clear to that judge signing it that there was a parole warrant on him, and you cannot bond out on a parole warrant. After the charges were filed, the detective contacted the defendant's parole officer to inform her of the incident. He then created the photo lineup, the photo array that he had initiated, and presented it to the victim, and the victim was able to positively identify the defendant in that photo lineup.
And then what was, I think, really nice, a month after the disclosure of the incident, the victim witness counselor received a letter of appreciation from the victim, and he said that he had, in fact, utilized the counseling services and had disclosed what happened to his mother, who is very, very supportive, and that he did, in fact, want to proceed with the investigation and prosecution of the offender.
This defendant and this victim witness counselor had an extremely good rapport with each other, and I think that was very helpful in getting this case to trial.
Mm-hmm.
So how it works, here in my county, we're a grand jury state, and we can present a case to a grand jury based on hearsay alone. So typically what happens in a sexual assault case is it takes about a month for the case to come to my office. I'll review the case, and I'll set up a pre-grand jury meeting with the victim to explain the process, answer any questions she or he may have, and to inform them that the grand jury may want to hear testimony from them. Sometimes they do, and sometimes they don't. So I did that with this victim, and he indicated at that time that he was willing to cooperate. We had a victim witness counselor that was trying to stay in touch with him. He had been released from jail at this point when the judge that was in charge of his case, his family violence case that he initially went into the jail on, heard what happened. He released him on a personal bond, and the victim moved to another city with his mother. So we presented the case to the grand jury. They did not want his testimony. It was just me and the detective. The other option here in Texas is if a defendant requests, you can have what's called an examining trial. We never have examining trials because if a defendant, it's mostly just to keep the prosecutors on a tighter timeline. If a defendant requests an examining trial, we can just put the case in front of a grand jury, and that takes care of it, and it's indicted at that point. So the other thing on a grand jury indictment is you can bring witnesses, whether they're uncooperative, if you think they might not be around or they might pass away. You can take victim sworn testimony in front of a grand jury. We did not do that in this case because it was pretty straightforward, and the grand jury did not request any of that.
Yeah, so your jurisdiction is unique in that you can indict based on hearsay, which other jurisdictions you can. In many jurisdictions you cannot. And, of course, they all depend on whether it's grand jury or preliminary hearing and what the practice of the state, the locality, and certainly the judge. So these are things that can vary based on jurisdiction. One of the things that we definitely want to consider at this stage, and not only at this stage, the preliminary hearing or the grand jury stage, because of what Mona just mentioned, you don't know if in certain cases your witness will be available for trial. I want to go back to even that initial contact with the first responding officers and the importance of having those first responding officers talk to the victim about witness intimidation. So the PREA standards contemplate witness intimidation and retaliation and acknowledge that the potential for intimidation and retaliation in cases of sexual abuse and confinement can be pretty high. So they have these standards set up so that internally the confinement facility can deal with these issues, with separation, with protection, et cetera. But those first responding law enforcement officers really have to be talking to the victim about intimidation, letting the victim know what kinds of behaviors constitute intimidating conduct, that the intimidation may come from the defendant or may come from others. the defendant's friends or allies or group members, or in cases where the defendant is a member of a gang, other gang members. And the law enforcement officers, those first responders, have to work with the facility and then have a clear conversation with the victim so that there is a very quick and easy way for the victim to be able to report any kind of intimidation. And that means that the system will be set up not only to keep the victim safe, but then for us, as the persons charged with keeping communities safe, keeping our victims safe, we would be able to immediately investigate and charge the conduct appropriately. If we don't have the ability for the victim to report it, we can't do anything about it. So we've got to be talking about our victims about that, about intimidation very early on. And then at the preliminary hearing or grand jury stage, if we think that there is a possibility in those cases where there has been intimidating conduct, where our victim is very fearful or may, for other reasons, not be available to testify at trial, what we would want to do is pass all discovery and provide the defense attorney with a full and fair opportunity. That's the case law requirement, the full and fair opportunity to cross-examine the victim. We would want to do that at the earliest possible stage in case our victim is not available at trial.
And so after the case is indicted, it gets assigned to a trial court, and the defendant gets appointed a lawyer. And then typically what you see is now we have plea bargain negotiations going on, and that did not happen in this case because this defendant maintained his position of, this didn't happen, I didn't do this, I want a trial. So we get set for trial. It was important in thinking about how to try this case to realize that most of our jurors have never been to a jail. And so it was important for me to figure out how to visually show these jurors what we're talking about here. So we went back to the crime scene. We took more photographs. I subpoenaed a copy of the fire escape route, which showed a diagram of the unit so that the jury could see how they related to each other. And we talked to the jail staff and figured out who our witnesses needed to be able to describe that facility and how this could have happened without somebody seeing it or somebody intervening to stop it. On this particular unit, there were 94 inmates being supervised by 2 officers. The officers are not even in the actual unit. They are sitting in observation stations outside, and so there's on one side there's a unit, and it's just full of bunk beds, and the bathroom is off to the far left, and the guards are watching these inmates through windows. And the same thing on the other side. The second guard is watching a second group, exactly the same layout. The officers don't have intercoms in the unit, and there is no visual access into this bathroom. Once you go to the far left to go through the door, the officers cannot see or hear what's going on in that bathroom. And so I thought it was crucial to have visual of that and also testimony of that so that the jury could understand that this was an extremely isolated place, that this defendant found this victim and pushed him into the shower. And that's why nobody heard or saw anything, because of the layout of these units and the minimal supervision that's provided. So once we identified who our witnesses were going to be, we started with witness preparation, And at this time, the victim had been released from jail and had moved into another city with his mother, and he would not respond to us anymore. We tried to contact him with phone calls. We sent him letters. We had an investigator try to serve him a subpoena. We had local law enforcement in the town they were living in helping us to try to serve him with a subpoena, and we were not able to find him. But I had noticed in the offense report where the victim witness counselor had updated with when she got the letter from the victim, and she had updated her report and said that he had told his mom what happened. And so based on that, I called his mom, and she at first was telling me, I don't know where he is. I can't, I haven't seen him. I don't know. But then she would ask me questions that made it clear to me that she had been talking to him about the case and that they were his questions. So I just called her once a week for several months and just talked to her and just told her I'm not going to make him do anything he doesn't want to do. I just need to talk to him. I'm not going to make him testify if he doesn't want to, but I think it's important for us to meet so I can answer whatever questions he has. in my experience as a prosecutor, usually if you can get your hands on that victim, you can get them to the point where they're willing to testify. So I called her. We get set for trial, and I called her several times over the weeks leading up to it, and she kept telling me she didn't know where he was. I called her the Friday. We were set for trial on a Monday. I called her the Friday before and told her if I didn't have contact with him that I was going to have to dismiss the case on Monday because I couldn't go forward without him. And that's when I received a phone call on Sunday morning from his mom where she said that he would be willing to meet with me. So I met them halfway between our cities and met with him, and he was willing to testify at trial. In preparing other witnesses, I essentially just prepared them in the same manner that you would prepare witnesses for any other trial. I was trying to make this as visual as possible and make the jury believe, or to give the jury the impression that we had a lot of evidence. Juries like things to hold on to. They like things they can talk about and look at. And so we did a lot of pictures, a lot of videos, just to support the testimony of the officers and the victim. So it was pretty consistent with other trial preparation. I didn't have a lot of, other than the victim being in jail, there wasn't really a lot of bad facts or bad motives that I had to deal with. You would think there would be in a case like this, but I really didn't encounter that. The only place I did encounter that was with the classification sergeant, who was the one who had made the decision to put this defendant on this unit with other first-time offenders like this victim. And she was very defensive and said she didn't believe that the victim was telling the truth and that we shouldn't pick on the defendant. He said he didn't do it. Also in this case, in looking at what kinds of motions to file or what kinds of pretrial issues that needed to be looked at and discussed, I filed expert notifications for the DNA sample. The DNA came back with no DNA on it. But it's still important, I think, to make sure that juries understand that you took that step to do it because they want that scientific evidence so badly. I also notified the defense of our SANE nurse examiner as an expert and a fingerprint technician as an expert because a lot of times, like you know, that's how you get your prior judgments and sentences in is through a print person. I filed 404B notices, which included all those convictions that we went through before. I had subpoenaed this defendant's prison and jail records, and based on his criminal history, and there really wasn't very much in those prison and jail records to enhance the idea that he was a bad guy. But again, if you don't have that, that's a really good place where you can get some 404B stuff or some punishment evidence is in those jail records because they document everything. And that was really all I filed. I did not file a motion in limine in this case because I thought that with this particular victim and this particular set of facts, I just wanted the jury to feel like we were being as honest as possible with them. He was a very believable person, and I thought, you know, it was strategically better to just put all the facts out there and let them know everything. So I did not file a motion in limine with regard to anything about the victim. And of course, that's a strategy decision that you need to make in each individual case because when you're talking about prosecuting and you have a victim that is a person society may feel judgmental about, you know, obviously what you want to keep out and what you want to let in is a case-by-case decision. So I think you just need to strategize on each individual case.
Mona, before we transition to voir dire, I just want to go back to what you talked about earlier in terms of bias from the classification supervisor. And clearly, because you did such good witness prep, you were able to learn about this bias and then determine what you would do at trial to keep this witness sort of on track, to keep the bias, try to keep the bias out. Did you have some clear conversations with that witness about keeping the testimony factual, or what other strategies did you employ to try to keep that witness on track and to explain that she wasn't permitted, nor was it her job, to opine on a witness's or victim's credibility?
I actually determined that I could get everything I needed as far as the classification rules and evaluations and the things that they used to make that decision in through other witnesses. And so I just gave notice to the defense and had a conversation with the defense attorney about I think she's, not an appropriate witness, and y'all can call her if you want her. And so I didn't end up calling her, but I was clear with the defense attorney why I wasn't calling her, and, I think that's kind of borderline Brady. And I said, she's on my subpoena. I'm happy to get her here if you want her, but she's y'all's witness. I'm not putting her on.
I mean, that's the whole point of prep, so that you know these things. So in terms of knowing all these things and then being able to prepare for voir dire, certainly for the non-prosecutors, we want to mention that really voir dire practice can differ depending on a state, county, or judge. And regardless, prosecutors, even if there is a prevailing practice in the jurisdiction, prosecutors should really consider making argument, and those arguments can be really persuasive, that jurors with firmly held but mistaken beliefs about rape are unlikely to be able to follow a court's instruction on the law, and that specific questioning in this area is the only way to determine the prevalence of the rape myths in the jury panel. So the prevalence of the rape myths and the potential of bias against an inmate victim, I think prosecutors can argue, weigh in favor of judges creating exceptions to a practice that they might have of strictly limiting juror voir dire in sexual assault cases. Again, depending on the jurisdiction, depending on the state, the county, and the judge. And even when these questions are allowed, the practices differ greatly across the country. So in some jurisdictions, the prosecutors can ask questions directly or submit questions to the judge. And in others, there are limitations. And Mona's going to talk about what can occur in Texas and what occurred in this case.
So we're pretty lucky here in Texas. We get to talk to the jurors ourselves, and we get as much time as the judge gives us. And the judges in my county are pretty generous. We usually get to we usually get to talk to the jury panel for about an hour per side. And there are certain things we talk about in every case. We talk about, like the defendant asserting his right to remain silent and whether people can follow the law. They can't hold that against him. We've always voir dire on police officer bias, because most of our cases have police officers. There's certain things, the burden of proof, we always voir dire on that. There's certain standard things that we always talk to juries about to make sure that they can follow the laws that apply to every criminal case. And then you have to think about things that are important to the case that you're trying, that are specific to that case. And I thought that maybe because this happened in a jail, I was worried that I would have a jury panel where people would have bias towards this victim. And so I talked to this jury about who are potential victims of sexual assault. And we talked about gender. We talked about males can be victims. And then I talked to them about what if somebody puts himself or herself in a situation that society might be judgmental about. And I gave some examples. For example, a prostitute or a drug addict that's passed out on the street, or someone that breaks into someone else's home, just things that you would think that a jury would react to. And I asked them, can that person who society thinks puts himself in a vulnerable position, can that person still be the victim of sexual assault? And so we talked to them about that, and I didn't really get very inflammatory responses in this particular panel, but I still think it's important to talk about it every time because you never know when you're going to get someone who's just, comes unglued about that. And so the ultimate question that I asked them was, even if someone puts himself in a position that we consider less than savory, is that person still deserving of the full protections of the laws of this state, just like everybody else? That's the ultimate question. Can you follow the law? Is this person entitled to the same protections as everyone else who says that they were sexually assaulted? And so we can strike people for cause if people are going to be judgmental towards your victim because of he was in jail. I also ask in sexual assault cases, this is a question I ask almost always, I ask the jury panel, what types of evidence would you expect for the state to bring you in a sexual assault case? And I do this because, number one, you can ferret out your people who say, I want it on tape. I want it beyond all possible doubt. And you can strike for cause your people who can't hold you to your proper burden. I also do this, and I'll talk about this when we talk about closing, because it ties in very nicely to being able to have an organized, compelling closing argument. Because typically, you're going to be bringing them what they're asking for, pictures, DNA, physical things that they, like I said, tangible things they can hold on to. Typically, you can bring them those things, and you can tie it to the victim's testimony to make that testimony more credible. So once I figured out who we needed to talk to and who we needed to get off this panel, and we, of course, talked about what demographics we thought would be good for this type of case and all of those other jury selection issues that you come up with, we then started to think about how to present this case to a jury, what the witness order should be. And I always, in sexual assault cases, sandwich my victim in between professional witnesses, so to speak. So the first witnesses that the jury are hearing from are witnesses, usually police officers, first responders to the scene, people who they're taught to respect, people who are used to testifying, people who are going to give your case credibility from the very beginning. That's a pretty big burden to put on a victim, to have that person be the first thing out of the chute. And the jury, I just feel like they're more judgmental unless they have a good, solid foundation. So in this case, I started with the corrections officers who took the report. All of the people that the two officers interviewed in the jail, the actual two officers themselves, the first responders. And I talked with I got in the classification information through the people who to testify about how this defendant ended up on this unit. And once we had laid the groundwork and the jury could see through all those officers what it is we were talking about, I then put the victim on. And with this victim, I thought he wasn't going to hold up well. We needed to just get in and get out. And we needed to tell the jury everything. So I just had him explain how it was he ended up in jail and just tell the facts of the case from the start to the beginning until he was released from jail. Then I put on the victim witness counselor because they had such a good rapport and she had done such a good job of documenting what she saw in him. She was able to testify that when she saw him, he was shaking, he was crying, he was upset. And that's why it's important to train your report writers, because if he had told her those things, she couldn't have testified to that. But because she saw them, she was able to corroborate his story by telling the jury what exactly it was that she saw. Then I always end with science, because that's what juries are looking for. Juries want science. They want something to hang their hat on. They want to feel good about their verdict. And science is boring. Everyone thinks they want DNA, but it's boring. And so if you end with that, you close your case with your most credible evidence. And then you can or can't put on the lead detective to tie up. Sometimes I put them on in the middle. The lead detectives kind of fit in. Sometimes they make a nice bow to your package at the end, and that's what ended up happening here. And so the corrections officers were not testifying as experts in this case. They were testifying about things that they saw. They were giving me the time of day. They were giving me the description of the unit. They were giving me the dormitory style and how this could have happened. They were giving me what you could see and hear from their locations. And then obviously the victim's giving what the victims give. So as far as opening arguments go, I didn't know if I was going to have people on this jury that did have biases or judgment. You never know, and it's especially important in sexual assault cases. So I never oversell my case in an opening of a sexual assault, especially this one, because I hadn't ever done this before, and I didn't know where these jurors were going to be coming from. So I just gave a linear explanation of the facts, and I didn't oversell. I told them what evidence they could expect to see. It's important in cases like this, if there are bad facts in your case, you need to just address them right up front. You need to be taking care of that so you don't lose credibility. And sometimes you can incorporate a theme. I did not in this case because I felt like the facts were pretty straightforward. The victim was believable. The reason he was in jail, we don't like people to push their girlfriends around, but he could handle the cross-examination on that. And So I didn't have a theme. I just thought put it out there as cleanly and most organized as possible. And so that's what we did. With regard to the victim, I already touched on some of this a little bit. I just had him to talk about the circumstances of his arrest, how he ended up in jail, and direct testimony about the facts and to meet all of the elements of my offense.
How was the cross of the victim, Mona?
The defense attorney tried to cross him about the underlying facts of why he was in jail, and he didn't really get very far. He was not an aggressive defense attorney, and so he didn't really gain much on cross. And I think he realized that he wasn't doing the case any favors by beating up on this kid that had already been beat up. So he didn't really do a whole lot on cross.
Mm-hmm. Yeah, I think what's really interesting and important for us as prosecutors to note is that a lot of times in sexual assault cases, the defense attorney will spend the overwhelming majority of the cross-examination talking about anything and everything except for the incident. Mm-hmm. That's for the rape. And that's a very important thing for us to point out in the closing. You know, that if you're trying to test the veracity of statements, wouldn't you be asking about the incident in question, the reason that we're in court in the first place? And in these cases, oftentimes that is the opposite of the strategy by defense.
And I think because these are cases that are kind of unusual to try, I mean, we don't see these tried a lot. I think what both lawyers realized pretty quickly is we need to get to the point as quickly as possible without seeing blunt or rushed, because everybody in that room was uncomfortable. And so I think the defense attorney kind of realized that, and he realized that he was making the jury more uncomfortable by trying to do an aggressive cross, and so he just stopped. Mm-hmm. With regard to exhibits, in sexual assault cases, sometimes you have to make up evidence. And I don't mean that to say that you have to cheat but you have to give juries something to hold on to, because usually there's not a lot of physical evidence. So, for example, if a sexual assault happened at a house, I always put a picture of the house. Does that matter? Well, not really. I mean, it doesn't mean an element of your offense, but it gives them context. It makes the story real. Jurors are visual people. So we had a bunch of photographs of the jail and the unit. We had better photographs of the shower. We had photographs of the victim's injuries that were taken by the responding officers. And in my jurisdiction, the SANE reports always come with a body diagram, and that's where the nurse is documenting any external injuries. And then it becomes, in this particular case, it came with a diagram of the anus, and that's where she documented the tearing, and a diagram of the penis, and that's where she documented the injury on his penis. And I always blow those up to poster size, because I think it's really important for the nurse to be able to point to them and show the jury, and the jury can have a visual of those injuries without being so graphic that they're offended or turned off by it, because really it kind of just looks like a big, outline of a body. And so I find that's a very successful way to show juries injuries that occur during a sexual assault without traumatizing your victim or making your jury so uncomfortable that you alienate them.
And even in a case where there is no injury, to still, when you're calling that medical expert to testify about why there is no injury, to testify about anatomy, et cetera, it's still helpful to have that diagram. That's a really good point.
And it's helpful, too, because like you said, no one puts themselves through a 90-minute exam, and it gives the jury a visual of just how intimate that exam is. When you're showing them a giant blown-up vagina or an anus, it really impresses upon them how invasive this really is, and that's important. So in addition to pictures, we introduced the SANE kit, we introduced the blood that was drawn at the SANE, and we introduced the buccal swab that was done by the detective of the defendant to be our known sample for the comparison. We sent it to the DNA lab, and there was no DNA on the swabbings from the SANE exam. But what the jury gets by you putting on that witness anyway is they understand that you took the time and the money and the resources to do that, because this is important. And you follow that DNA report or the DNA analyst. You put them after the SANE examiner, because the SANE examiner can testify that in her training and experience, 72 hours later, given that he had showered and used the bathroom, you wouldn't necessarily expect to find DNA on that swabbing. So you put the two pieces together and it makes sense.
And Mona, in this case, you had mentioned that there was not an expert who was called to testify on victim behavior specifically, but that kind of testimony came out through certainly the victim himself, through how he felt about the assault, and also through the victim witness counselor and the other witnesses, that a lot of the information came out in other ways. But in certain cases, depending on the facts and the other evidence, prosecutors will want to seriously consider calling an expert on victim behavior. And that's because of what we spent time talking about during the voir dire section of this webinar, and that's our jurors buy into myths and misperceptions about how victims should react during and after an incident of sexual abuse. We want to select the experts carefully. We want to select an expert who has significant experience working with survivors of sexual abuse. We want to consider calling advocates, counselors, social workers. You can call an experienced member of law enforcement who's worked with survivors over the years. You can call someone from an academic institution who has clinical experience, and preferably an expert from outside of the jurisdiction in which the crime occurred. That expert should be contacted by the prosecutor and should be explained to what the reason for the expert request is, without explaining the specific facts of the case. So explain, I have a victim who is an adult male, and I'd like you to submit a report on general victim behavior during and after an incident of abuse, and I'd like you to perhaps emphasize the following behaviors and discuss whether these are common or you've seen these in your experience, as well as what is in the research and literature. You want to identify this expert as soon as possible and submit the report as far in advance of trial as possible, so that if there is going to be a defense expert, you can do the necessary research on this defense expert, whether this expert has testified before, has written before, et cetera, et cetera, et cetera. You can identify experts through many different ways, through your statewide coalition, through other prosecutors in your state, through other agencies, including AEquitas, and then those agencies and persons can help you prepare your expert for trial and can also try to find out if your expert as well as defense experts have testified before. So Mona, talk to us about what in many cases is the most important part, or one of the most important parts of the entire trial, and that is the closing.
And so in voir dire, I ask them, what type of evidence would you expect the state to bring you in a sexual assault? And you get answers like DNA, documentation of injuries, excuse me, photographs, and whatever other, and typically you can bring them those things. So what you can do in closing is say, you asked me for these things, and I brought you all of this physical evidence. And physical evidence doesn't lie. And if what a witness is telling you matches that physical evidence, you should assume that they're telling you the truth, because physical evidence doesn't lie and they're matching up. And that's it's a very powerful way to strengthen the quality of a victim's testimony by linking it directly to that physical evidence. And I did that in this case, and it ended up working well. There wasn't a lot to say in this. We talked about, in closing, I talked about how you can't really say that this victim had a bad motive because he lost credit time by moving off the unit. Talk about all of the hardships he endured to get away from that defendant, and that bolsters his credibility as well.
What happened?
And then we submitted the case to the jury, and about 2 hours later, we got a guilty. And so in Texas, there's two phases to every criminal trial. There's the guilt-innocence phase, and that's where you present evidence about what we're saying happens, the criminal activity. And once you get a guilty, you move on to the sentencing phase of trial, and that's where you can present who this defendant is and what this crime did to this victim. This victim wanted to leave right after his testimony. He didn't want to stay, so he was released from his subpoena, and he did not testify at sentencing. But the defendant took the stand and testified at sentencing and told the jury that they got it wrong. Because he was on the stand, I introduced his 24 prior convictions through him. And what happens usually is while the jury's out deliberating guilt, innocent, we typically have we do a 10-print card on that defendant, because if he doesn't take the stand, you get the judgments and sentences in through a fingerprint expert who can link that 10-print card to his prior judgments. When we were attempting to do that, the defendant threatened our print analyst, threatened to kill him and tried to kick him, so we put that person on to talk about how violent the defendant was after he was convicted. So typically, a sexual assault here in Texas, the punishment range is 2 to 20 years in prison. In Texas, if you have 2 prior trips to the penitentiary, you are then enhanced to what we call a habitual offender. Habitual offenders' punishment range is always 25 to 99 years or life. In this case, when the jury got the case at sentencing, when they went back to deliberate, within minutes they sent out a note to the judge asking which is worse, 99 years or life. And I guess they decided 99 years was worse because they sentenced him to 99 years in prison. He's eligible for parole after 30. So after the trial, I attempted to contact the victim again through his mother. She answered. I told her what happened with the case. I told her to have him call us or the victim witness counselor if he had any questions or needed anything else, and we never did hear from him again. The defendant was transferred the next week to the classification division of the Texas Department of Criminal Justice Institutional Division, and he remains in prison today. Here in Texas, we get to talk to our jurors after we have trials, and they typically really want to talk to us. They have questions, and they want feedback. So this jury, we got to talk to this jury, and this jury said that they did not have any issues about the fact that this occurred in jail. They were very clear that in their minds, somebody wouldn't come forward and say that this happened if it didn't happen, and they gave a lot of credibility, for good or bad, to the fact that it was a male victim. And the men especially said a 24-year-old man would never get up and testify that this had happened to him if it didn't. And so while it helped my case, his burden of credibility was much lower, I think, than sometimes jurors make our women live up to. But so that was helpful to talk to the jury, and I think the take-home message from that jury was, don't be scared to try these cases, because we're not going to just dump them because this happened in a correctional facility or a locked facility.
So it is interesting, Mona, to consider that there was potentially, the impression that the jurors gave was a reverse gender bias in this case. Yeah, very interesting thing for all of us to consider.
Yeah.
And we've heard from some prosecutors in different jurisdictions across the country express concern about prosecuting cases of sexual abuse and confinement. And perhaps the main concern that they've expressed is that, well, these cases aren't winnable, so we're not trying them, or we're not trying many of them. And I think a concern that we have is, and Mona, of course, I know you share this, is if we as prosecutors aren't trying those cases, how do you possibly know what the result of the case will be?
And I can understand where that fear comes from, because I got a lot of pushback from my coworkers about why are you making such a big deal about this? This happens all the time. That's just what happens. And so I had a really acute awareness of what to address with that jury, because I thought I was going to encounter all those biases from them, and in this case I just didn't.
Right. If you had encountered the biases from the persons who are charged with seeking justice, then obviously you're going to have some concerns with members of the general public. And then, in fact, they were able to listen to the evidence and follow the jury instructions and ultimately convict. And the other important thing for us to keep in mind is, again, we're charged with seeking justice. And so our definition of success should not be obtaining a conviction. They should be included in our definition of success. But success is doing our jobs, doing the right thing, investigating these cases, prosecuting these cases while supporting the victim throughout the entire process so that we can, at the end of the day, know we did everything we could do to be supportive and then attempt to keep our community safe, whether that community is inside or outside the walls of confinement. So thank you for sharing the information about this case and talking about the real fear that some of us have or continue to have, not only for cases of sexual abuse and confinement, but for these cases in general, and how important it is for us to overcome these fears and to do our jobs. Charlie, do you want to just take a minute to wrap up and talk about some additional resources?
Yes, thank you, Vicki. And I want to thank both Vicki and Mona for their presentations today. Thank you, guys. And to thank all of you as well for participating in today's webinar, as well as all the work that you do on a daily basis. You can find more information out about our resources here on the slide. Our special initiative page, which talks about our relationship with the National Pre-Research Center. Additional resources are also available on our library page, more on witness intimidation, Crawford and its progeny, forfeiture by wrongdoing, and there's some other additional information. And like I mentioned before, this presentation was recorded and will be available for later viewing on our training page, on the training page of our website. We'll also be following up with you guys via email, providing you with the presenters' full biographies, a handout of the PowerPoint you saw today, and a link to a survey regarding today's presentation and our presenters. So thank you all again so much for your participation, and everyone have a great weekend.
Thank you.